I recently filed an amicus brief regarding the Ninth Circuit decision in the Sanchez-Gomez case that ended the long-standing safety protocols for restraining detainees in the courtroom during pretrial arrangements and hearings. It's obviously very important for Arizona. We have a very busy docket, particularly as it pertains to immigration. This amicus brief I filed had the support of the National Sheriff's Association, Western State Sheriff's Association, and the Arizona Sheriff's Association. As you know, we have a lot of historic courthouses in Arizona that don't lend themselves well to separation between detainees and the public, often having to share hallways or doorways, and without the long-standing restraint protocols that existed, it makes it impossible to actually bring a number of people through the system, and it will really hobble law enforcement in Arizona. Have you looked at this, and how do you believe this decision, the Ninth Circuit, will impact the courtroom?
I would be glad to look at it. I'm not familiar with it, although the issue's been one out there for a long time, and my experience is that judges decide that fairly day after day. Some people just need to be shackled, I've always thought, but they don't do it unless they feel like it's really necessary. I would think the Ninth Circuit or the case would reverse that long-standing policy?
That's correct, and it would basically, I mean, obviously we have protocols and court decisions with regard to jury trials and the appearance of somebody who is restrained, but this is just arraignments and whatnot before a judge, and it really puts our court officials, security officials, the public at risk in many circumstances, or it ties up our sheriffs and other law enforcement officials from actually going out on the beat and doing what they should do to actually having to be in the courtroom at all times. So it's really a problem, particularly with regard to implementation of something like Operation Streamline, which we've spoken about many times. It really inhibits the ability to move the number of people through the system quickly enough, because where we used to be able to have 30 or 40 individuals there arraigned at the same time, now they can only do 6 or 7. And so it simply makes it impossible to move through the docket. So I appreciate the DOJ's position on this, and I hope that the U.S. Supreme Court grants cert there.
We will review it.
Okay. With regard to sex and human trafficking, earlier this year, the Permanent Subcommittee on Investigations concluded a 2-year investigation on Backpage.com, which revealed that the company knowingly facilitated online sex trafficking. In July, the subcommittee, under Senator Portman's leadership, referred the case to your office for criminal investigation. Can you tell us, to the extent that you're able, what the status of that investigation is?
I don't believe I can. I'm not able to now. Would be review as to whether or not I can comment on it and what the status may be.
Okay. We'll check back with you on that.
Thank
Mr.
you.
Chairman, I have letters of support from the Stop Enabling Sex Traffickers Act, a bill I co-sponsored with Senator Portman and several of my colleagues, that would prevent companies like Backpage.com from committing online sex trafficking crimes. And these are letters from the National Center for Missing and Exploited Children and other anti-trafficking advocates that I'd like to submit for the record.
Without objection, your letters will be received.
Thank you, Senator Flake. And this human trafficking is a priority of ours. My Deputy Attorney General feels strongly about it. The Associate Attorney General, Rachel Brand, has made that one of her interests and made a couple of speeches on that recently. We can do more, and we will do more.
Okay, thank you. One other item. You mentioned in your opening remarks with regard to civil forfeiture that you'd put some protocols in place in terms of more speedy notification of those whose assets were seized. What other protocols and what are we doing to ensure that we have a better system than we've had in the past? I'm convinced that this has been abused at just about every level of law enforcement, state and federal.
We intend to respond to any problems that are out there that we identify in the future. When the government has probable cause and feels able to seize money, usually, drug trafficking money usually, they have a certain period of time to respond. We cut that by at least half, if not, I believe, a little more than half. And we've directed our assistant United States attorneys to monitor the state authorities and the DEA to make sure the systems are working well. We have required that before we adopt a case from the states, that they be trained in proper procedures for a federal court system and not just any police officer, so they know what they're supposed to do. And I think that will be a big help. And I believe there's some other things. And then I don't know if you were here, but I did announce, send out Monday a directive to establish a asset forfeiture accountability officer who will be in the deputy's office and who will be monitoring all these cases, complaints that may occur, so we're going to respond promptly. We want this system is really important, Senator Flake. It's a top priority of every law enforcement agency in America, but it's got to be run right, and that's going to be our goal.
Well, cutting the time in half for notification is cold comfort for some who have this stretch on for months and years. So I hope that we do more than cut the time in half for some of these.
That's just one of the things that would happen. We want to take nothing but good cases. We're winning at the 90% level, and most of these cases are pretty open and shut. So I hear what you're saying. I know your concerns, and that's why I am not taking it lightly. We're going to monitor this program.
Thank you. Thank you, Mr. Chairman.
Thank you.